A several years-long dispute between the city of Boise and a neighborhood association is cruising into more confusion. Back in 2019, City Council gave the green light for a 38-acre housing development in Northwest Boise. Neighbors pushed back, citing concerns about fire coverage and safety. State law requires the city to address those concerns when making a rezoning decision, which they did, but neighbors said that wasn't good enough. And 2 weeks ago, the Idaho State Supreme Court agreed. Yet even during this legal tangle, several houses were being built, and now more construction continues. Is that legal? Well, short answer is yeah, it is. Andrew Bartline gives us an update on the Northwest Boise Neighborhood Association.
It's a victory on paper.
A Supreme Court decision says they invalidated the decision of City Council back in 2019 to rezone the planned unit development and the subdivision.
But it's less than a win.
It's moving faster.
In practice.
Faster than ever.
Despite the ruling giving the neighbors an impression, this should be put on pause.
I would tend to agree with that.
Richard Llewellyn is the president of the Northwest Neighborhood Association. He wrote an email to the city of Boise the day of the Supreme Court ruling. He requested the construction stop.
Until they can fulfill what the Supreme Court is requiring from them.
City Council chose to rezone this 38-acre plot for a 220-unit housing development in 2019. State law requires the council to provide a written statement that factually addresses concerns.
And if you don't do that, then a neighborhood, residents, the Supreme Court can't actually evaluate the rationale for your decision. So it is a necessary step.
It's a step the city didn't take, at least not properly. The state Supreme Court opinion says, quote, no findings of fact.
In order for the process to have any legitimacy, that has to be done well.
But the city disagrees. The decision to rezone was legitimate, at least enough for the project to continue forward as normal.
Just going ahead as if it never happened really doesn't seem like a good public process.
But it's endorsed by the city of Boise's public statement. The city emailed Richard September 14th, writing in part, quote, because the Supreme Court did not find fault with the public hearing process or anything else leading up to the 2019 decision, the grading and construction currently happening at the site can continue. It's echoed in court opinion, where they say the city did misstep, but the error did not prejudice the neighborhood association's rights. Therefore, these are not grounds to reverse the city council decision. But the court also gave council suggestions.
The opportunity to hold public hearings.
And update on the original hearings from back in 2019 with an entirely different mayor and an old city council. The common thread from then to now.
We have a motion and a second discussion.
Current Boise Mayor,
yes.
Lauren McLean.
It's essential for that transparency that Mayor McLean ran on 4 years ago.
But rehearing the concerns they failed to address in the first place is not required.
They seem to be defaulting to this kind of the same attitude that the Supreme Court called them out on.
But it's a winning attitude. Resubmit the document with a little more effort does make it a win for the city on paper.
There's hardly anybody working at the city anymore in the planning department that was working there in 2019. So a lot of what was agreed upon has been forgotten already.
The city of Boise did not respond to us at all when we originally ran this story 2 weeks ago. We went with no response till today, and they declined an interview, but the city did submit a statement to us. It is the exact same 4-sentence statement, word for word, that the city gave the neighborhood association a week prior to today. As for the steps forward, Brian, the city is waiting on an order from a district court. That's what the Supreme Court said. We're going to push this back to the district court. They need to give them an order to resubmit this documentation.
Okay.
The city, in the meantime, says we're working on that. Our legal team is ensuring that we're getting everything in line that the Supreme Court says we need to do, which by the word of the law is here are the complaints from the neighborhood association, the people that live there. You need to factually address those.
I may be simplifying this, but to me it sounds like, okay, so as a parent, it's like saying yes to your child, what you do is wrong, but not enough to ground you for this weekend. You can still go out and have go out with your friends.
You just described what I was hoping somebody else could describe to me earlier today, because that's essentially what it is your due process rights were violated.
Yeah.
However, you weren't prejudiced in the process. Therefore, we don't care enough to do anything about it. Just do the paperwork correctly this time. Well, the neighborhood association says, we want to have a conversation. It seems that the city says that conversation's over.
Yeah, well, the story is not over yet. We'll see what happens. All right, thanks, Andrew.